In this session, we're going to cover constitutional law as it applies to businesses. As a little bit of a heads up, constitutional law is a very difficult subject. Um, Constitutional law covers a lot of theoretical type topics, and it's very dense at times. Uh, in law school, constitutional law for me was a class that met every week twice for 2 hours each time. So we covered about a 2,000-page textbook, as well as cases of significance that had happened since the textbook was first published. And so it was a very thorough class. And here we're covering all these difficult subjects in a matter of about 40 pages and just one class. So what you'll see today will be bare bone principles of some of the highlights of constitutional law that could apply or could affect businesses. Let's begin initially with a little bit of an overview of the U.S. Constitution. As everyone knows, the United States sought independence from England, and as part of that process, once we did win independence, we had to set up a government. The U.S. Constitution is the founding document upon which our government, the federal government, is based. The Constitution was ratified in 1789. The Constitution is made up of articles that set forth the three branches of government as well as their interplay among one another. A couple years later, in 1791, the first 10 amendments were adopted and became a part of the Constitution, and those amendments make up what's called the Bill of Rights. And this defines what we're seeing as very common and important individual rights. Since 1791, there have been 17 additional amendments that have been adopted and are now part of the Constitution. So in this class and in this section, we're going to look at primarily the U.S. Constitution. But all states have a constitution. Tennessee has a constitution that sets up the founding of the government for the state of Tennessee. So in this class, in this session, we're going to talk about the U.S. Constitution, but many of the principles may have a commonality with the state governments, the state constitutions. The state constitutions, however, are all different and not universal. So the Constitution defines the structure of the U.S. government. There are three branches that everyone probably knows about. You have the judiciary branch, and that's like we talked about last week when we looked at the makeup of the court system. You have the Supreme Court, then the Circuit Courts of Appeal, and the United States District Courts, and that's the trial court level. The next branch of government is the executive branch, and that's the one that everybody thinks of as the president. Then the legislative branch is that's Congress, which is made up of the House of Representatives and the Senate. You have the three branches of government, but the Constitution sets up a doctrine that's known as the separation of powers. So if you think back to history as to the reason we're leaving England and we want independence is because of the problems that existed with a centralized government of a king. And so when the founding fathers adopted a form of government and drafted the Constitution, they were trying to ensure that no one branch of the government had too much power. And so the separation of powers is the notion that the government is divided into three branches that serve as a check and balance on governmental control. So take an easy example. Congress has the authority to pass legislation. It's got to pass through the House of Representatives and the Senate, and it's got to be agreed upon by both bodies. Once it's there, then it goes to the president, who has to sign it. The president has the veto power. The president can reject a bill. It can then go back to the Congress, and if the House and the Senate pass it or if the Senate passes it by a 2/3 vote, it can become law. But that doesn't mean that it's not a check and balance once it becomes a law. Once it becomes a law, then the judiciary has the authority to review it and declare a law unconstitutional if it is. So you see how there's a check and balance system, that no one person has too much power in the government. So the Constitution is really works towards separating the powers that the states have from the powers that the government has. So the U.S. Government's powers are all derived from the Constitution. If a power is not granted in the Constitution to the U.S. government, then the power is reserved for the states, meaning that if the government doesn't have express authority, or authority, when I say express, authority found in the Constitution, not necessarily it's got to be written in there, but if the court can find a basis or power for it from the Constitution, maybe implied, which you will see when we talk about fundamental rights. There are a number of rights that have been implied from provisions of the Constitution. They're not specifically enumerated in there, but the courts have found implied authority. But if the authority comes from the Constitution, the government has it. If it's not stated in the Constitution, then it's reserved for the states to legislate and decide. So without power in the Constitution, the government can't act. This is why you hear of the courts declaring something to be unconstitutional. If it's unconstitutional, then it's in violation of the Constitution. And it may be for various reasons. It may violate the Equal Protection Clause. It may violate the Commerce Clause. It may just be a lack of authority for the government to enact the legislation that they're trying to enact. It may be something that's reserved for the states. As we've talked about kind of before, you have times where both the state and the U.S. government will try to regulate the same issue, the same topic. An example is gun laws. There are both federal gun laws and there are state laws, and so you can have similar laws on the same topic. They just can't conflict with one another, and that's where we've talked about with the doctrine of preemption. If there's a conflict between federal law and state law, federal law is still going to be the one that controls. It's going to be the one that prevails. The state law is going to be held unconstitutional. So this notion of judicial review, we're just talking about the power of the judiciary to review acts of Congress. It can also review acts of the president. But in the case of Marbury versus Madison, which is an early and very seminal Supreme Court case, the Supreme Court established the doctrine of judicial review. And the court's reasoning was that the courts must determine what the laws are, and implicit in that is they've got to determine whether action taken by the government is legal. So courts therefore are vested with the power to review the actions of both the executive branch and the legislative branch to determine if the acts are constitutional. That means, do they have the authority to do what they did? So if the act is contrary to the Constitution, then the act would be deemed unconstitutional and therefore would be void. It would no longer continue to be the law. The first topic let's look at is the Commerce Clause. The Commerce Clause is located in Article 1, Section 8, and it states that Congress has the power to, quote, regulate commerce with foreign nations and among the several states and with the Indian tribes. So the Commerce Clause provides the federal authority to regulate commerce, and it also has what's called the Dormant Commerce Clause that we'll talk about in a moment, which provides a basis for federal authority to restrain state action to regulate commerce. So the types the type of instances that would fall under this is that you would have federal regulation of interstate travel, labor relations, and discrimination and accommodation. So the way that the courts have interpreted the Commerce Clause has changed over the years. Initially, the Commerce Clause was interpreted very narrowly, but after the Great Depression, the court began to interpret the Commerce Clause broadly. And when they interpreted it broadly, in order for legislation to constitutional. All it was required that the legislation have a substantial economic effect. So they were looking for some nexus between the legislation and the economic effect. And if you have a substantial nexus there between the legislation and an economic effect, the court would uphold statutes as being constitutional within the power granted by the Commerce Clause. So from 1937 until 1995, the Supreme Court virtually held up all laws that were under the guise of commerce. So if Congress could pass a law and it was something they wanted to regulate, they would just say that it was had a nexus or some effect on commerce, and the Supreme Court, when faced with it, would uphold it. Let's look at the example given here by the Heart of Atlanta Motel versus the United States case. This is a very famous case if you take common law over in the future. And in this case, there was the Title II of the Civil Rights Act, and that was a law that prohibited businesses from discriminating or segregating on the basis of race, color, religion, or national origin in places of lodging. So hotels, motels, inns, wherever else that's similar to that, whatever other name you can give to it, if they had 5 or more rooms that they rented, they were within the purview of Title II that prohibited them from discriminating based on race. And this case was from the mid-1900s, and so this was at a point in time where segregation was very common. And so the Heart of Atlanta Motel, they discriminated against African Americans because they refused to rent rooms to persons of African American descent. So the motel, they challenged Title II. They said it was unconstitutional under the Commerce Clause. The Supreme Court upheld Title II as constitutional. It found that there was a substantial economic relationship based on the motel's solicitation of patrons from outside and inside Georgia. And it was persuasive to the court that 75% of the guests were from out of state. So there you see your interstate commerce that's happening here. There's an economic effect in this instance. And people were commonly traveling across state lines in this instance, and they're staying at this hotel, especially since 75% of patrons came from out of state. So African Americans were being discriminated against in violation of Title II. In the end, the court struck down the hotel's practice. So the motel was in violation of Title II, and Title II is a valid exercise of the Commerce Clause. So the motel could no longer refuse to rent rooms to African Americans. So it was all you had to look for was a substantial economic effect. Well, in 1995, the Supreme Court, in a reversal after over 50 years of cases, finally struck down a law as in violation of the Commerce Clause. The case was the United States versus Lopez. In that case, the statute being challenged was the Gun-Free School Zone Act, and that act banned guns from being located near schools. The court found that Congress had, this is my opinion, Congress had kind of come to expect that they had this deal where we could just say Commerce Clause that affects commerce for some reason, even if it was a very minor reason, and it would be accepted. Well, in the Lopez case, the court finally said, no, we're putting some limits on it. And so Congress basically failed to offer any sort of persuasive justification for the act. They didn't put forth a good showing that the act was related to some form of interstate commerce. The court found that it didn't regulate interstate commerce. Rather, it prohibited people from having guns near a school. Can you think of any, while maybe it's a good law, can you think of any basis that it has as far as affecting interstate commerce? And even then, is it a substantial effect that it's having on interstate commerce? I can see how that the court's ruling is correct in finding that it doesn't have a strong effect on interstate commerce. So the court found that they failed to offer a compelling or a convincing reason for them. The argument that the government put forth was an argument that gun possession could result in violent crime, which in turn may affect the national economy by increasing cost, reducing travel because it would be deemed an unsafe place, and it could lead to reduced productivity based on a perceived effect that guns near a school could have on a learning environment. The court found those arguments to be too tenuous, too far-fetched. The court saw them, in my opinion, as a slippery slope argument, meaning that if we granted in this, we essentially put no limits on the Commerce Clause. With this argument, anything could be deemed to be affecting interstate commerce, and then Congress would have authority to pass most any law it wanted to. So as the court put it, is that if they looked at it like this, then any activity that Congress could say may lead to violent crime or that relates to economic productivity of citizens would be within the realm of the Commerce Clause, and they could legislate very broad and find a basis in the Constitution for it. In the court's view, permitting this gun-free act to stand would set a precedent that would result in no limitation on federal power. So another Commerce Clause case that's more recent is the National Federation of Independent Business. And this is the challenge to Congress's authority to enact the Patient Protection and Affordable Care Act. That's the act that's more famously known as Obamacare. So this is the act that required that persons have insurance coverage. And so the Supreme Court was asked to look at it on a couple of bases, but the one of interest here is, did Congress have the authority to pass the Obamacare under the Commerce Clause? The Supreme Court concluded that the act was not authorized by the Commerce Clause. They said that Congress could not regulate commerce by compelling individuals to participate in commerce, this was not a valid exercise under the Commerce Clause. You can't require somebody to purchase insurance. Again, the court, in my opinion, saw this as a slippery slope argument. Congress would then have the power to regulate citizens, quote, whenever enough of them are not doing something, close quote, that the government believed they should do. In my opinion, this goes back to kind of being contrary to the government's founding. You don't want the government having too much power. That's why they have the different forms of government. They're the different branches of government to put a limitation on the power that can be exerted. And if the government gets to where they can start compelling individuals to do something that they believe they should do, there's definitely an overstep of power in comparison to what was originally intended to be set up. But let's say this real quick before we go on the Dormant Commerce Clause. With the case, everybody knows Obamacare has been upheld, and they upheld it because they found that it was an appropriate tax under Congress's authority to enact taxes. So we've talked about the Commerce Clause and how the government has the authority to regulate matters that affect interstate commerce. But now we'll look at the Dormant Commerce Clause. And the Dormant Commerce Clause is basically, even if the federal government has an act, they could sometimes still restrict a state from acting. So we go back to what we've talked about both earlier today and in our sessions last week about federal law preempts state law. But can federal law preempt state law when there's no explicit federal law on it? The answer is yes. Under the Dormant Commerce Clause, a state's actions may be restricted even if there's no, quote, federal law that's been enacted. Rather, the Commerce Clause of the Constitution provides a check, a limit on state power. So the idea is that Congress was granted the power to regulate interstate commerce. Therefore, the Commerce Clause implicitly limits states from enacting laws that would unduly burden or discriminate against interstate commerce. So if you have Congress doesn't take any action, but the state takes action. Well, if it's something that is left to the state to regulate and they haven't regulated it, then that means there shouldn't be a regulation on it. So there are certain things that may be found that there are certain laws that states may enact that may be held to be unconstitutional as violating the Dormant Commerce Clause. So the analysis in the Dormant Commerce Clause cases is you first consider whether the state statute is discriminatory or neutral on its face. If it's discriminatory, you stop there. The statute is considered to be unconstitutional. But if it appears to be neutral, then the statute is considered to be unconstitutional if it has a discriminatory purpose or effect. If there's no discriminatory purpose or effect and it's neutral, the law would be permitted. Once you've considered that, you consider whether the state can rebut the unconstitutional presumption. So if it's either one of the first two that we found, where there's either discriminatory on its face or it's neutral but has a discriminatory purpose, then you would consider whether the unconstitutional presumption can be rebutted. To rebut it, you've got to survive strict scrutiny review. Strict scrutiny, we'll cover it in just a few slides later when we talk about the Equal Protection Clause. But just quickly, strict scrutiny requires that you show that the law is necessary to serve a compelling state objective or legitimate local interest. So strict scrutiny is a high burden to meet, and you basically have to show that it's necessary to serve some legitimate interest or state objective, and to a degree that there's no other alternative that would not be discriminatory to enact. So this is your basically your last resort, is what you're showing, is that in order to achieve the purpose you need to achieve, you've got to have this discriminatory law. So if the purpose and effect of state law is not discriminatory, but it does affect interstate commerce, then the courts must balance the burden on interstate commerce against the local state interest and its benefits. So you still have to look at it and make sure that it doesn't unduly burden interstate commerce. And this is, again, serving as a check because the Commerce Clause gives the government authority to regulate interstate commerce. And so what you're doing is you're making sure that what the state is doing does not violate the Constitution. So if it's an infrequent or an insubstantial interstate effect in comparison to the state's benefit, the court will permit the state law and will not find it void in light of the Dormant Commerce Clause. So another thing that the Constitution has is it protects individual liberties. So you've got some protections that are found in the Constitution, such as the Contracts Clause. The book covers that briefly. Other protections that are found in the Bill of Rights, and I've just hit a few of the first ones that are more widely known, is the First Amendment. You have the freedom of religion, freedom of speech, freedom of the press, and freedom of assembly. Second Amendment gives you the right to bear arms. That's what gun owners rely upon to have their authority to own and control and use guns. Fourth Amendment, this prohibits unreasonable searches and seizures, and it requires that a court have probable cause before they grant a search warrant or an arrest warrant. And a probable cause means that they've got to have a good faith basis for believing that you've committed a wrongful act. So the 14th Amendment contains what is known as the Due Process Clause, and that prohibits any state from depriving any person of life, liberty, or property without due process of law. 14th Amendment also includes the Privileges and Immunities Clause, which states that no state shall make or enforce any law which will abridge the privileges or immunities of the United States. The Supreme Court has held that the 14th Amendment incorporates the Bill of Rights. So the first 10 amendments are incorporated into the 14th Amendment, and through the 14th Amendment are binding on the states to the extent that it's fundamental to the American scheme of justice. So essentially, the Bill of Rights applies to the first 10 amendments applies to the U.S. government, but through the 14th Amendment, the Supreme Court has held that the certain rights under the Bill of Rights are incorporated and binding on the states, meaning that the states have to accept the First Amendment's right of freedom of speech and of religion, and the Second Amendment's right to bear arms. So let's explore the freedom of speech. First Amendment states, Congress shall make no law abridging the freedom of speech or of the press. The First Amendment is not unbridled. There are limits on it. Not all speech is protected speech. And then even at that, you may be able to place reasonable limits on the speech without violating the First Amendment. In that same vein, even though speech may be free and there things may be said, you cannot require or compel someone to say a certain speech either. So while it gives you the right to say it, it doesn't require you to say something. So unprotected speech. There are a couple different types of unprotected speeches. One is speech that has a clear and present danger of inciting imminent violence. Here's a quote from the case that's in the book. The question in every case is whether the words are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has the right to protect. Now, clear and present danger as being unprotected speech, this doesn't come about very often. Most of the cases that have found it have been in like a wartime setting or a heightened political setting that's going on. There's something else going on, just not, it could come up in other areas, but it's just not a very often applied to find speech to be unprotected. Obscenity, this would cover more things, like you get into looking at pornography and things like that is falling more into obscenity. And for obscenity could also include vulgar words and things of that. So for speech to be obscene, it has to be these three requirements. One, the speech must appeal to a sordid and perverted interest in sex. It must have no serious literary, artistic, political, or scientific merit. And lastly, it must be, on the whole, offensive to the average person in the community. The last form of unprotected speech is defamation. Defamation, it's a state law claim. We'll probably talk about it later in torts chapter. We'll talk about it. But defamation is a false statement that damages a person's reputation. So there's different standards that apply on defamation concerning whether the person is a public figure or not. If they're a public or political figure, then you have to show that the false statement was made with actual malice. Actual malice requires a showing that you either knew that the statement was false when you made it, or you had a reckless disregard for finding out whether it was false, whether it was truthful. So defamation, false speech would not be protected. Freedom of speech, prior restraint. This is where you have a lot more of the cases that come up. You will see these cases in which there's a governmental action in which they say, we prohibit you or we limit you from speaking. And this happens, as it implies with prior, it means that this restraint or this limit or this prohibition on speaking or other form of expression happens before the speaking. So an example is if you have a statute or regulation that requires a speaker to obtain some permit or license before speaking. That would limit, arguably, them being able to speak. You could also, if that permit or license is denied, then you're restraining their ability to speak before it occurs. The government could also forbid speaking. We had a case that I helped defend a few years ago that included a First Amendment prior restraint claim. And in that, it was a governmental official the government was being sued because a governmental official told the employee, who was the plaintiff, that she could not engage in making certain statements. She had been making statements out in the community, and they were statements in opposition to what the government was doing. The governmental official didn't like it, told her she couldn't make them, and there was a prior restraint claim that was made. So that's an example of the government forbidding this individual from engaging in free speech. So prior restraint is disfavored, and it's often found to be unconstitutional when you tell somebody you can't speak, or you try to limit them from being able to speak. Freedom of the press. The press right now is at an interesting time with all the political fodder that's going on between them and the president, in which people begin to question the press's motives and their authority to speak as being, because oftentimes, some people at least, they're seen as being biased and not impartial in delivering information. But nonetheless, the freedom of the press is rooted in the First Amendment. And so the notion is that the press should be free to publish information to help the country, to provide sufficient information so that people can make an informed decision, especially as we approach elections and as we'll approach in 2020. The concept is that the press should be allowed to publish information and have that right to let the nation be informed and let them be well informed, especially when it's time to elect new officials. And so the New York Times versus the United States is a good example of prior restraint involving the freedom of the press. So in that case, you had the New York Times and the Washington Post who wanted to publish what were considered to be confidential documents. They were known as the Pentagon Papers, and they were a study, a confidential study on the Vietnam War. So the government, in this case, sought to quash the Times and the Post publication of these documents, and they did it based on a confidentiality nature of the documents, as well as their classified status as documents that are not to be made public. The Supreme Court held that the government failed to satisfy the, quote, heavy burden, close quote, that's required in order to justify imposing such a restraint, especially since there was no showing of an imminent harm or damage that would occur to the nation. So while a document was perhaps considered confidential or highly sensitive, they weren't able to show that publication of that document would create an imminent harm or damage to the nation. And so that's a good example of where there was a check on the freedom of the press. They were allowed to print and get information out, and the government was not able to restrain that from happening. So freedom of speech, political speech is protected by the First Amendment. That includes speech that's critical of government decisions and officials. So the example that I told you of the case I defended based on the prior restraint claim previously, the lady was engaging in political speech. She was being critical. She was criticizing some of the government decisions and some of the officials that were making them. That's political speech. That's protected by the First Amendment. Another example that comes up quite often with political speech is burning the U.S. flag. The United States Supreme Court has held that burning the flag is protected speech under the First Amendment. Commercial speech. Commercial speech is subject to regulation. You can put reasonable regulation restraints on time, place, and manner. And under commercial speech, false or misleading commercial speech may be prohibited. And when we say commercial speech, we're talking about speech that relates to business, selling things, advertising, things like that would fall under the ambit of commercial speech. So you're not protected under the First Amendment to make false or misleading advertisements. You can't seek a defense if a customer gets something and sues you for making claims or false advertising. It'd be a common law tort type claim under state law. The defense to it is not going to be that I was engaging in protected First Amendment speech, because commercial speech is not going to include the false and misleading statements that you'll make. So to restrict commercial speech, the asserted governmental interest in regulating speech has to be substantial. The regulation has to directly advance the government's interest, and the restriction has to be as limited as possible. So it can't be any more restrictive than necessary to serve its interest. So also another part of the First Amendment is freedom of religion. And there's two provisions that are part of the First Amendment that relate to religion. You have the Establishment Clause and the Free Exercise Clause. The Establishment Clause prohibits the federal government from establishing a religion. As they said it, the government has to remain neutral in matters involving religion. So an example is that it's been held by the Supreme Court that the Establishment Clause prohibits teachers and students from leading prayer in public schools. As we talked about earlier, the 14th Amendment's Due Process Clause is found to incorporate certain rights and requirements under the first 10 amendments, the Bill of Rights, to the state governments. And this is one that's incorporated under the 14th Amendment. The Free Exercise Clause is one that limits the government's powers to restrict the citizens' practice of religion. So the government can't enact laws that are meant to suppress religious beliefs or practices. So it goes to the freedom of religion notion that a person should be allowed to participate in any religion that he or she sincerely believes in. The Due Process Clause is another part of the Constitution that's very important and often used. So you have the 5th and the 14th Amendment. They both have due process clauses. The 5th Amendment is the one that applies due process to the federal government. The 14th Amendment is what applies due process to the states. So under these clauses, the federal and state governments are precluded from depriving any person of life, liberty, or property without due process of law. So out of this due process has come two types of cases. So there's procedural due process and there's substantive due process. We'll look at each here in just a moment. Procedural due process. Procedural due process is concerned with fairness in a legal proceeding. So when you have a government that takes action, a government act that affects a person's life, liberty, or property, that's what the due process clause covers. If government takes action that has an effect on a person's life, liberty, or property, the procedural due process clause requires that the government give that person notice and hearing before the governmental action is taken. So before you take action, you've got to give them notice and a hearing. So the notice, it has to be a good notice. You can't just say, we left a sticky note on the curb of his house. You have to give notice that's reasonably calculated under all the circumstances to apprise the interested party of the action and afford them an opportunity to present their objections. Without proper notice, you're going to have a procedural due process problem. The notice must provide enough information about the governmental action. So you don't need to say a date or a time, you need to explain to them what's going on, what governmental action is going to take, when it's going to be taken, and that they have an opportunity to discuss it in a hearing. Tell them when the hearing is. So you can't give notice, and it's got to be reasonable in the amount of time that you give them to make an appearance. You can't give them that notice and give them 12 hours to make a decision or to before the hearing. You've got to provide sufficient notice. And again, that depends on the facts and circumstances, but it's pretty easy to know we need to tell them what we're doing and give them a 2-week notice before the hearing. That would be oftentimes found to be reasonable. So the exact format of the hearing, again, varies based on the circumstances of what governmental action is being taken. But what is clear is that the format must provide the person an opportunity to be heard. It has to be a meaningful opportunity. So an example of procedural due process often comes up when you have a governmental employee who has a property interest in his job. If they're terminated, then they would have the right to a notice of it and a right to a name-clearing hearing. Name-clearing hearing is a hearing in which the individual has the opportunity to address the charges against him or her that's forming the basis of the termination. And they would have the opportunity to present them and have it considered and heard. And it could be that whoever the hearing officer or hearing panel is decides to reinstate the person. It may be that they decide to affirm termination. But in that instance, they've got to be given notice and a hearing in which they can present their objections to the governmental action. Substantive due process. Substantive due process covers what is known as fundamental rights. And you may have heard people claim that, well, such and such is a fundamental right or such and such isn't a fundamental right. When you hear people talking about fundamental rights, it's deriving from the substantive due process clause. And the fundamental rights are rights that the government is not supposed to interfere with. So the fundamental rights, like I was talking about earlier in the lecture, the Constitution does not just enumerate all the fundamental rights that there are. Rather, the rights are inferred or implied out of provisions in the Constitution. So the Supreme Court has been the one who's identified these rights over the years, and they've identified the fundamental rights as being protected by the right and liberty interest of the 5th and 14th Amendments due process clauses. So we'll look at a few of these contexts in which substantive due process has been applied. So economic regulation. The Supreme Court initially applied the substantive due process clause narrowly, and they would strike down laws that regulated economic enterprise. The example provided there is discussed briefly in the case, but it's the Lochner versus New York opinion. There they found that the statute that put a cap on the hours worked was unconstitutional. But since 1938, the Supreme Court has applied substantive due process broadly. And if you'll think back to when we talked about the Commerce Clause, at about the same time, the court began applying the Commerce Clause very broadly. So the makeup of the court at that time clearly made a shift, ideologically at least, from what the Supreme Court had been for a number of years. They started to see things more broadly. And so they applied the substantive due process clause as well as the Commerce Clause broadly to give greater authority to the government in their ability to restrict. Or not necessarily to restrict, but to regulate. Some of it's restricting, but some of it's not necessarily a restriction. So under the current test, if there's a rational basis for economic regulation, then the statute will be considered constitutional, meaning that it comports with the substantive due process clause. Fundamental rights and regulation. Fundamental rights are considered to be the most important paramount rights that a person possesses. Fundamental says it all and what it means. So laws that regulate or restrain a fundamental right are usually deemed unconstitutional. For them to not be unconstitutional, the government has to show that it promotes some compelling or overriding governmental interest. This is a pretty high burden for them to meet. Fundamental rights that have been acknowledged by the courts is the right to marry, the right to have and raise children, the right to travel, the right to vote, and the right to privacy. Substantive due process and punitive damages. Punitive damages are a measure of damages that can be awarded by a jury in a tort action. So if you have a negligence case, a component of damages may be one compensatory damages, and that's damages meant to compensate you for the injuries that you suffered as a result of the person's negligence. But they could also seek punitive damages. And punitive damages are damages that are meant to serve more as a punishment or a deterrent towards such conduct. Punitive damages are meant to set an example such that both the defendant as well as others will not want to repeat that conduct. So it's meant as a punishment, a deterrent. The Supreme Court has held that the substantive due process clause limits the amount of damages, punitive damages that may be awarded. So when we talk in a couple of weeks, when we study torts, remember as we talk about that there's punitive damages, but punitive damages are limited by the due process clause. For companies, they can be sued for punitive damages and be awarded sometimes millions upon millions of dollars as in punitive damages, as a measure of punishment for their egregious conduct. Eminent domain, this is the concept that authorizes both the federal and state governments to take property for public purposes. So eminent domain is where they condemn property and they annex it more or less to create some public purpose, such as a school or a park. The Fifth Amendment, as well as the 14th Amendment through the incorporation, provide that the government may not take private property without providing you with just compensation. So if I own property along the road, and the government decides that's a great piece of property, we would like to put a park there, they can exercise their eminent domain rights and they can condemn that property and take it from me. However, they have to give me just compensation for it. So they just can't take my property and I'm out. I just lose my property. They've got to give me fair compensation, reimburse me fairly for my property. In these cases, what often becomes the critical component of it is when has the government taken property such that compensation is owed? And you may have examples where you think the example I just gave you of is very cut and dry. You know when they're taking your property from you. Well, you have other forms of takings that occur based on restrictions. So you could have a regulatory taking. A regulatory taking is where the government enacts some law or regulation that substantially restricts your ability to use the property. If they restrict your ability to use the property to where all it can do is sit there as an empty lot and you can't build anything on it or you can't hold gatherings on it or anything like that, then the property may be taken by the government through their actions of enacting those regulations. So in that instance, it's not always clear when the government is taking property such that compensation is owed. The Equal Protection Clause. This is the last major topic that we'll cover in this chapter. The Equal Protection Clause is in the Fourth Amendment. It states that no state shall deny any person within its jurisdiction the equal protection of laws. So the Fifth Amendment imposes the equal protection clause on the government. So under the Equal Protection Clause, to establish a statute violates the Equal Protection Clause, the statute must be shown to discriminate against a class of persons. Discrimination may exist in several ways. One, it could be based on the face of the statute. It's based on the text of the statute. The statute may say this class of people are treated this way, this class of people are treated another way. That's not as common now as it used to be back when in the 50s and the 60s when there was segregation and persons were treated differently based on their skin color. But it's still a possibility that based on the text of the statute, there could be discrimination. Discrimination could occur also based on the statute's application. That the statute may be applied differently to different classes of persons. The example for that's from recent years is the treatment of same-sex couples compared to other couples. So that group of people has been treated differently than people of opposite sex, couples of opposite sex. So that would be one in which a statute is found to be discriminatory based on its application. It's applied differently to different classes of people. Then you have where it could be discrimination based on the purpose. It's where you look at the face of it and its application of the statute. It doesn't show it, but there could be an intent or a purpose to place differing burdens on a class of persons. And so there's a discriminatory purpose, even though it's not written or happens in application, it could be subject to an Equal Protection Clause invalidation. So there are three factors that the courts are to consider when they determine if a statute is discriminatory against different classes. One, the practical or statistical effect of the statute on the different classes of persons. Let's look at and see, is it affecting the people differently based on either statutes or an actual application? Second, you look at the history of the problem that the statute is supposed to fix. So if you have, is it a problem in which you can see that there's a discriminatory purpose or intent in it? Then you also look at the legislative history. That's the last point. Legislative history is just like it sounds. It's what was said when this statute was being drafted and adopted and approved by Congress. Oftentimes there's discussion that happens, and there'll be records of that. And then when the bills go through their different processes, there's explanations that's written to accompany the text of the bill, of the proposed law. And so you can look back at the written notes that accompany the bills and the different changes. You can look back at the discussion that occurred in the Senate or the House on the bill. You could look at what the committees decided to do. And looking back at the legislative history can give you a good idea of what's the intent or purpose behind the statute. And you may be able to deem whether it's a discriminatory intent or not. So as we've talked about a little bit so far in today's lecture, courts will apply different standards that have to be met in order for a law or a statute to survive, even if it's found to have some repugnancy with the Constitution. So we've mentioned a couple of these. We mentioned strict scrutiny earlier, and that's what we'll talk about in a minute. But the easiest basis is the rational basis test. This is that a statute's classification based on how it's treating people, that is, so its differing treatment of people will be permitted if there's a conceivable basis on which the classification might relate to a legitimate governmental interest. And this rational basis applies to statutes that regulate economic and social welfare. So an example is tax categories. If you think about your taxes, you have different classifications of percentages of taxes. So if you make between $0 and $15,000, you pay 8%. And this isn't the right numbers, but you can see what it is that you have the different classes. And so depending on how much money you make, you pay more in taxes. And so that is found to be a regulation of economics and social welfare that would meet rational basis. That is tax categories, even though it's based on some sort of classification based on um, income and social status, then it is considered to be constitutional. So when we talk about these three bases or three different tests, the rational basis, intermediate scrutiny, and strict scrutiny, um, you're going to see this language of, like, for this one, it's that this classification is allowed if there's a conceivable basis on which the classification might relate to a legitimate governmental interest. Well, when I hear test, I think of things of like, okay, well, I need to have an easy way to know what I'm doing is right or wrong. And with these tests, they're not black and white. You may think, well, this is going to be meeting rational basis, but upon inspection, it may really not. So there's not a bright line rule to these. It's based on facts and circumstances, and it's hard to know exactly whether it survives these three tests. Intermediate scrutiny is the next one. A statute's classification will be permitted if it is substantially related to an important governmental interest. So again, it's got to be substantially related. Before, it was just if it has a conceivable basis, and it's got to be substantially related to an important governmental interest. Well, what's important to me as a governmental interest may be vastly different to someone else, and in turn, what's important to that person may not be important to me. So you can see how there is the gray in these tests. But intermediate scrutiny has been found to apply to statutes that classify based on gender and legitimacy of birth. The last and the highest level test that has to be met is strict scrutiny. And under this test, a statute's classification is permitted only if it is necessary to promote a compelling state interest and is narrowly tailored to achieve that interest. So now it's got to be a compelling interest. Again, what's compelling to me may not be compelling to someone else, and vice versa. But it also has to be narrowly tailored to achieve that interest. So the classifications can have to be used as narrowly as possible in order to achieve what they're seeking to do. So it has to be basically the best option that you have to use the classifications. And strict scrutiny has been applied to statutes that classify based on characteristics such as race or religion, and also to statutes that involve limiting fundamental rights. So the Equal Protection Clause was enacted with the purpose of helping eradicate racial discrimination. If you go back, there used to be from the late 1800s through the mid 1900s, there was this doctrine known as the separate but equal doctrine. This doctrine permitted governments to treat minorities differently by providing services and facilities that were separate from the facilities that were given to white persons. And that was permissible so long as the facilities were equal. So you could have one set of bathroom for minorities and another set of bathrooms for whites. And that was okay as long as they were separate and equal. So Brown versus the Board of Education is the famous case decided in the 1950s that abolished the separate but equal doctrine. In that case, they held that school children may not be segregated or discriminated against solely on the basis of race. The court concluded that if you're segregating based on race, then you're depriving the minorities of equal educational opportunities. And so the separate but equal doctrine was overturned. So the Equal Protection Clause limits only apply to governmental entities, so that's state and federal. The Equal Protection Clause does not apply to private employers. So when we talk about this intent of eradicating discrimination, you may think, does that mean private employers can discriminate? Well, hold on, because in a few weeks when we cover employment law, we will learn about Title VII and how it prohibits, among other things, discrimination based on race, religion, and other similar characteristics.